Right, welcome back everybody. Our next speaker is Eitan Makowski, who practices in the common law, statutory comp, admin law, and is now calling himself an expert in medical panels as well, because that does seem to be a growth area. So Eitan did his articles at Williams Winter, completed a Master of Laws at Melbourne University, focusing in negligence, equity, remedies, defamation, litigation and advocacy. And he's about to cover most of that except the defamation in the next 24 minutes. So this is going to be an excellent summation of the Common Law 101, I think. Eitan, as I said before, does both plaintiff and defendant work. And I'll hand over to him now.
Thanks, Geoff. Now, I've provided you with a paper, and doubtless there'll be parts that I just won't be able to cover in the limited time. I'll try and speak clearly, but I'm going to try and go as quick as possible so I do cover most of the aspects. Some of the topics I'll talk about will include, as you can see, paragraph 1, employees' non-delegable duty of care. Then I'll talk about independent contractors and their general duty of care. The topic of the reasonableness or otherwise of a worker's refusal of treatment and mitigation of damages. I'll touch on breach of statutory duties versus negligence, have a quick talk about contrib, and hopefully get to occupiers' liability and the formulation of a duty of care. The main cases which cover those topics are listed there. I won't read them out. And I'll jump right into what we always hear, the non-delegable duty of care. In this case of Fennell, the plaintiff brought proceedings against his employer and Alcoa. Alcoa retained Silcar. The plaintiff alleged negligence and breach of statutory duty. The plaintiff suffered injury when he was working as a maintenance worker for his employer. As I say, that employer was retained by Alcoa. The work was maintenance work. The plaintiff was allocated the job by his employer at a toolbox meeting, those meetings we always hear about, but Alcoa, who was running the Portland aluminium smelter, gave to the plaintiff a job pack of documents which also described the jobs to be done, identified hazards associated with the job and recorded necessary procedures. In the process of turning after inspecting brushes at a particular brush station, if you look at the case, there's pictures in the actual case of what was going on. It's hard to visualise, but in any event, he was crawling, and in the process of inspecting the brushes and turning, having entered by the wrong door as it was, he hurt his right knee. The plaintiff settled with the defendants, but then the defendants proceeded with their contribution proceeding. Osborne, Justice of Appeal, held the following. The employer has to take the greatest share of responsibility because it had a non-delegable duty of care. That duty extended to taking account of potential inadvertence by the worker, which I'll come to when I talk about contrib. The maintenance contract pursuant to which Silcar undertook work at the smelter devolved ultimate responsibility for the implementation of the work upon Silcar being the employer. There were a cumulative set of factors which resulted in the breach of Silcar's duty to Mr. Fennell. What were those factors? Failure to supervise adequately when a direct inquiry by the worker as to how he should get into the brush station was made, and it must have been apparent to the employer's supervisor that the worker was unfamiliar with how to get into the brush station. In any event, Justice of Appeal Osborne concluded that the principal, which was Alcoa, had reserved to itself a supervisory role with respect to the maintenance of the work on its smelter. In particular, it had reserved the right to formulate the written job instructions, to control access to the confined space, which was that door I was talking about, and to provide ongoing supervision on the floor of the smelter during the carrying out of the maintenance work. Therefore, Justice of Appeal Osborne held that Alcoa had breached its duty by failing to provide clear written instructions, failing to properly control the access to the door, and failing to adequately supervise the job over which it retained a direct oversight on the floor of the plant. And as Honour continued, it might be said that the system of work was Alcoa's, that's the principle, and that it retained general control of its implementation and, in particular, control over access to the confined space. On the other hand, the employer selected, directly instructed and supervised its personnel, and it had the non-delegable duty of care. In all of the circumstances, at the end, His Honour held that the split should be 80% employer, 20% that of Alcoa. Notable aspects from the body of the decision include the following. The employer had the non-delegable duty of care, and it could not, in law, pass it back to Alcoa. The duty of care included a particular duty to provide adequate supervision and instruction as part of a safe system of work, and I've referred to a case which talks about what actually a safe system of work means. Mere inadvertence of the worker did not relieve Silcar of its duty of care, a well-known case of Mulkeen and Tedman, but I'll come back to what that means. And on the topic of general duty of care, that is Alcoa's, the principal, the important cases to note include latent contractors, some of you might have read, and the well-known case of Stevens and Brodrib Saw Milling Company. What does it say? An entrepreneur who organises an activity involving a risk of injury to those engaged in it is under a duty to use reasonable care in organising the activity to avoid or minimise that risk. And that duty is imposed whether or not the entrepreneur is under a further duty to servants employed by him. The entrepreneur's duty arises, and I've added in bold, simply because he's creating the risk, and his duty is more limited than the duty owed by an employer to an employee. It does not import a duty to retain control of working systems if it is reasonable to engage the services of independent contractors who are competent themselves to control their system of work without the supervision by the entrepreneur, which should make sense. However, as I said when I was explaining the facts in the case, Alcoa did retain some control over the system of work, and that is why Justice of Appeal Osborne noted that in such circumstances, the principal may owe a duty to an employee of the independent contractor to exercise reasonable care in the supervision of that employee's work. That is, Alcoa did have a responsibility to take care of Silcar's employees because there had been an assumption of responsibility for that supervision by the principal contractor. So a few points that you might take from that case. On the pleadings aspect, I know some of you might enjoy preparing your own pleadings. Think about the nature of the duties and who you're after. And conversely, if you're defending, think about, well, is there true vicarious liability? Are you admitting or are you denying that there's vicarious liability? Think about what the non-delegable duty of care actually means. Have a look at the documentation to ascertain whether or not the principal did retain some control like Alcoa did in the system of work, despite engaging the independent contractor. And in terms of risk management, those documents, which become the evidence in a case, think about them and prepare the documentation which delineates areas of responsibilities and job functions at the front end. Moving to a totally different topic now. I'm probably going too slowly. Mitigation of damages and refusal to undergo surgery. Case of Hobby, and I think it's always helpful to have a look at some New South Wales cases on Ausleets and easy click on the Court of Appeal because they have a lot of injury cases on a wide variety of topics, and I think it's worthwhile, and this is a New South Wales case. In any event, what were the facts of Hobby? The primary judge did find that the plaintiff worker was unreasonable in refusing treatment when she tore her ACL and needed a reconstruction. She declined surgery on 3 separate occasions. The third reason for the refusal was too scared to have the operation. The medical evidence said that following the surgery, the injured person could expect a return to close to normal function of the left knee. Court of Appeal of New South Wales on this point says that whether the refusal was reasonable depended on the knowledge of the benefits and risks of the surgery at the time of refusal. And it was held that the primary judge erred in failing to take into account that knowledge. There was no evidence that the doctors explained the benefits and risks of the surgery, and therefore the tortfeasor appellant failed to discharge its burden of proof. On the burden of proof, Acting Justice of Appeal Sackville, with whom the court agreed, noted that the appellant acknowledged that it bore the burden of proving that the respondent failed to mitigate her loss by unreasonably refusing to undergo recommended surgery. And we all might be aware of Watson Rake, but there is the burden on that party. And otherwise, the primary judge did not appear to have been referred in final submissions to the High Court case of Faslick on this issue. In that case, there was also a refusal by the injured person, the claimant, to undergo back surgery because of fear. The High Court said this: "No doubt it will be but rarely that an employer does not succeed in establishing a worker's refusal is unreasonable when the worker has allowed baseless fear to decide his choice, outweighing his knowledge of cogent factors favouring his undergoing an operation." But in that case, all that the appellant had to place in the scales and weigh against his strong and genuinely held fear of operation was the knowledge gained from his treating surgeon that it would be major, carrying some risk, but the chances were that it would improve his condition. And so I've highlighted there in bold, any assessment of the reasonableness or otherwise of a worker's refusal must depend on the worker's state of knowledge at the time. And so in the principal case, there was no evidence that the treating doctors explained to the claimant the reasons why they considered surgery was necessary, and no evidence they outlined to her both the risks and benefits, and there was no evidence that the doctors considered the refusal to be unreasonable. And so I suggest this case shows that the tortfeasor should have sufficient evidence that a claimant was aware of the risks and benefits and point to the claimant's unreasonable consideration of the objective reasonableness of the treatment, and a doctor's opinion on this issue would also help in discharging the burden. There is another point I make about pleadings, but I'll move on. If you are alleging failure to mitigate, it should be in the pleadings. The next case is about breach of statutory duty and negligence. The background facts are as follows. The plaintiff appealed a jury verdict which found there was no negligence on the part of the defendant, which was a cause of the injury, but there was a breach of statutory duty. One of the points on appeal was that no reasonable jury could have found that the defendant breached a statutory duty but also was not negligent. The argument was rejected. The background was the plaintiff was a secretary for Mr. Verducci. The plaintiff being a secretary, there was allegations of negligence, including a specific injury in 2007 when a chair moved, and then over a period of time moving, carrying heavy files and the like. The jury's, talking about the jury's verdict, by the way, the plaintiff was only successful in relation to breach of statutory duty, and I've put out the figures there, but there was a big discount for contributory negligence, 50%. From the jury's negative answer to question 1, that is no neg, the jury must have rejected the evidence that there was no carpet or mat under the chair. I can say it was a big, heavily fought trial, and it was a credit case. Additionally, the jury must have rejected the appellant's evidence concerning complaints made about lifting and carrying of heavy folders. And from the jury's answer to question 2, which were the regulations, it is not possible to know which of the tendered regulations the jury concluded were breached. The Court of Appeal restated what the primary judge said about the negligence and breach of statutory duty. The primary judge had said one final word on statutory duty. It's not a question of either negligence or breach. You can find neither, or you may find one or the other, or you might find both. And then the Court of Appeal spoke about what those two causes of action comprehend, and the Court of Appeal said that on the evidence in the case it was open to find that there was a breach of the regulations but no negligence. The breach of the regulation being that the respondent had failed to eliminate a risk of musculoskeletal disorder affecting the appellant. We've probably all looked at Regulation 15 of the 1999 regulations. There's more recent ones. However, a duty expressed in those terms sets a higher standard than that required by an employer to discharge his or her obligation to take reasonable care in respect of the safety of an employee. Similarly, the Court of Appeal looked at Regulation 14 and adverted to the possibility that the jury accepted there was no breach of the employee's duty of care when the respondent said that while he didn't perform the risk assessment, he did turn his mind to the relevant questions about employee safety. And in bold, the fact that it may now be said that a risk assessment, as required by the regulations, might have shown that there were deficiencies in the system of work of the employer, which deficiencies were causally related to the injury. It doesn't mandate a conclusion that at the relevant time the respondent considered questions of safety, that he was negligent in failing to comply with the terms of that regulation. Then the court looked at contributory negligence, which I'll turn to, because the appellant said jury assessment was too high at 50%. On the topic, the court refers to the well-known case of Podrebasek, 1985, in the High Court. What is contributory negligence? A finding on a question of apportionment is a finding upon a question not of principle or of positive findings of fact or law, but of proportion, of balance, of relative emphasis, and of weighing different considerations. It involves an individual choice or discretion, as to which there may well be differences of opinion by different minds. And such a finding, even if it's made by a judge, is not lightly reviewed, but you've got a great difficulty if a jury finds it. So moving on to contrib, sometimes it can be misconceived. Contributory negligence, again, the defendant bears the onus of proving that the plaintiff was contributorily negligent and that that negligence was a cause of the injury. It means that it will be shown if a plaintiff failed to exercise reasonable care for their own safety. And the High Court in that case that I've just mentioned does refer to McLean and Tedman from 84 and mention that the approach on the issue of contrib had to be done on the footing that the defendant had failed to discharge its obligation to take reasonable care. So you first start with whether or not there was breach, and then you turn to contrib. And in assessing any contrib, the circumstances and conditions in which the plaintiff had to do his work had to be taken into account. The question was whether, in those circumstances and under those conditions, the worker's conduct amounts to mere inadvertence, inattention, or misjudgment, or to negligence. The word negligence has a particular meaning. Further, it was noted that the making of an apportionment as between a plaintiff and a defendant of their respective shares in the responsibility for the damage involves a comparison of both culpability and the relative importance of the acts of the parties in causing the damage. Might be said it's a bit of a common sense approach. It's the whole conduct of each negligent party in relation to the circumstances of the accident, which has to be the subject of the comparative examination. And I'll just refer to another case, a more recent case, which goes through all the main cases you need to know on contrib. Moving to occupiers' liability, I think I can probably slow down now. So we'll take this a little bit slower. Occupiers' liability, again a New South Wales case. It's called Woolworths and Ryder. This case was about determining whether or not a duty of care existed, which is a very difficult question. The plaintiff slipped on soapy residue while walking in the common area of a shopping centre next to a Woolworths supermarket. The residue had been deposited by a child blowing bubbles from a bottle of liquid, which wasn't in dispute, was sold by the Woolworths. An employee of the supermarket was found to have opened the bottle when the child's parents were with the child at the checkout. The primary judge held that there was a duty of care, and what was it? It was to take reasonable care to prevent danger being created by reason of the use of products purchased at the supermarket, and also that the breach occurred by failing to warn parents against allowing the child to use the liquid to blow bubbles in the common area, and the injury happened in the common area next door to the supermarket, as I say. For present purposes, the Court of Appeal held that the duty of care had no basis. The duty identified conflated the reasonable foreseeability of harm with the existence of a duty of care, and it would impose an intolerable burden of potential liability on owners and occupiers of retail premises. And I'll come to why that's important if there's going to be an intolerable burden of potential liability as I go through the case. But on the topic of duty of care, Justice of Appeal Baston said as follows: identifying the duty of care was a matter of importance. The class to whom any duty of owed must have been members of the public present in the common area of the shopping centre immediately adjacent to the supermarket. And His Honour remarks, so stated, the difficulty for a person who was injured in that area is immediately apparent, insofar as responsibility was endeavoured to be brought home on Woolworths. It didn't occupy the area, that is Woolworths. It didn't operate a business in the common area. It had no exclusive control of the common area. And if it had any contractual rights or obligations with respect to the area, they were not identified. Going on, the failing in the reasoning of the primary judge was to equate reasonable foreseeability of harm with a duty of care, which is easy to do. Foreseeability of harm is a necessary element, but it's insufficient to create the duty. Identifying a duty is a prospective exercise, meaning don't apply hindsight, and you have to focus on the standards of careful conduct reasonably expected by the community. One problem is to formulate a duty in terms which would fit the known facts. If the duty is too narrow, by drawing from what actually happened, or what you say was done or was wrongly not done, there's a real danger of erroneously applying hindsight. And the other way is that if you draw it too broadly, it'll give you no guidance in identifying the boundaries of acceptable levels of care in particular circumstances and won't be accepted by a court. Acting Justice of Appeal Sackville expands upon the manner and way in which a duty of care is formulated and touches on the well-known case of Modbury Triangle. And His Honour says, foresight of harm is not sufficient to show that a duty of care exists. There's another case that His Honour refers to and says, reasonable foreseeability of the class of injury, you don't need to identify the actual injury, but the class of injury is an essential condition of a legal obligation to take care for the benefit of another. However, His Honour remarks, as Chief Justice Gleeson in Modbury held, the fact that the risk of harm was foreseeable in the sense that it was real and not far-fetched or fanciful is not sufficient to impose a duty on another person to take reasonable care to prevent the harm from occurring. In any event, the Court of Appeal recognised that the requirement of reasonable foreseeability involves more than determining whether the risk of harm was a realistic possibility. The requirement must be understood and applied with due regard to the consideration that, in the context of the issue as to duty of care, it's bound up with the question of whether it is reasonable to require a person to have in contemplation the risk of injury that is eventuated. And that comes to the extent or determinacy of liability. Otherwise, warns Acting Justice of Appeal Sackville, the law would impose on persons an intolerable burden of potential liability and constrain their freedom of action in a gross manner. His Honour recognised that often there's no difficulty in deciding that a duty of care exists in familiar relationships, which we're all aware of, road users, employee, employer. The difficulty, as highlighted in the case, the Woolworths case about which I'm speaking, arises in new situations or in circumstances which take the duty of care outside the usual characteristics of the relationship. And I've put in brackets unfortunately because it's difficult. In novel situations, there's no single touchstone to determine whether or not a duty of care should be imposed. The proper approach is to undertake a close analysis of the facts bearing on the relationship between the plaintiff and the putative tortfeasor by reference to the salient features or factors affecting the appropriateness of imputing a legal duty to take reasonable care to avoid the harm or injury. Some of you might remember the case of Perry and a Pan. Salient features. What are they? In this case, they included the degree and nature of the control able to be exercised. That is, Woolworth, what control do they have in this case of the common area? The nature or degree of the hazard or danger liable to be caused, any potential indeterminacy of liability, and the nature and consequences of any action that can be done to avoid the harm. The fourth point that His Honour makes reflects on the point that the question may not be whether or not a defendant, in this case it was Woolworths, can ever owe a duty of care to prevent a harm to a person who is not on supermarket premises, but the extent of any duty that might be owed. Finally, His Honour assesses the situation by analysing the fact that many stores, not just supermarkets, sell products that are readily capable of being used or misused in a manner that creates a hazard to others in the immediate vicinity of the store. His Honour says it's clearly foreseeable that a store selling takeaway food might create a hazard to shoppers nearby if consumers spill drinks or drop food in a common area adjacent to the store. Is the store owner or occupier of a kiosk to refuse a request to open a bottled drink because the customer might spill the drink? Should the owner or occupier refuse to unwrap a sandwich for a child because the child's quite likely to drop some of the contents on the floor? Why is the owner or occupier of a shop to be subjected to a duty to ensure that a child in the care of an apparently responsible adult does not cause mischief with products lawfully sold by the shop? Some of you might think of good reasons why. Accordingly, in the present case, Woolworths, as the occupier, was under a duty to take reasonable care to avoid hazards that might injure its customers whilst on its premises, and it was the owner or occupier of the centre who was under a similar duty to persons using the common area. It is difficult to see why the operator of the supermarket, Woolworths, should be subjected to a further duty to take reasonable care to prevent products it sells or simply opens for customers being used by persons over whom it has no control in a manner that creates hazards to persons outside its direct control or sphere of responsibility. And so finally, summing up that case, avoid using precedents if you're drawing your statements of claim or defences when you're formulating duties of care. Section 14B of the Wrongs Act is relevant, but it doesn't formulate the duty of care. It sets out the relevant standard, and it's the incremental approach that has to be applied and thought about when we look at what the duty of care, whether or not a duty of care should exist. I've just made some unrelated comments. The government response to the Wrongs Act inquiry is still considering whether or not 5% for spinal injuries. It has accepted that 10% for psychiatric will open the gateway, and the government's still considering the Mountain Pine amendment. Of course, if there's a change in government, that dot point might not mean much at all. There's also the Court of Appeal's new regime for civil appeals and applications, an extensive document. The changes have happened in the criminal sphere, and they're coming to the civil sphere, and I commend that document. Thank you for listening, and I hope you found it interesting. Thank you for coming.
Thank you, Eitan. Any questions? We've got about 3 minutes remaining, running to a very strict schedule here. Any comments? Anyone got any interesting cases? Ice cream spilt? Jokes? A couple of very good points there. One, all plaintiffs' lawyers should read the Occupational Health and Safety Regulations 2007. All sorts of things crop up in that, working in confined spaces, heights, manual handling. So you should have a hold on all of those. And the other one was that the New South Wales cases, for whatever reason, I think they've got a lot of acting judges in the district court, but there seem to be many appeals to the Court of Appeal there on personal injury matters. There's 2 or 3 a day that come out on Bar J, Net or Benchmark, so they're both good ways of following those cases. No questions, like an auctioneer? Going. Thank you very much for your attendance.